So that's what you have to bargain about. Another important thing to know is that both parties have a duty to bargain in good faith. Each of Vermont's labor relations statutes requires the parties to bargain in good faith with respect to mandatory subjects of bargaining. And the Labor Relations Board has developed a body of case law that provides some insights into what that term means. And I think the first point here is really the essence of good faith, that both parties are participating actively in deliberations with an open mind and a sincere desire to reach agreement. Some other examples here are illustrations of what that means. So you have to make honest claims at the table, including assertions about inability to pay. You can communicate directly with employees, but those communications cannot be coercive, cannot contain threats or promises, and essentially don't undercut the authority of the union as the bargaining representative of the teachers. And parties cannot unilaterally disclose or publicize confidential proposals or disputes in violation of ground rules. These aren't all the situations that constitute good faith, but they are some common circumstances that come up. Okay, so you've been bargaining in good faith on the subjects of mandatory subjects of bargaining and subjects that are within your master agreement. What happens when you cannot come to agreement? So there's a clear statutory process for dispute resolution in our teachers' labor relations law. And the first step is a declaration of impasse. So either or both parties at this point decide that third-party assistance is needed. Declaration of impasse doesn't mean that the parties have irreconcilable differences. It means that either or both parties have decided to move forward with the statutory dispute resolution procedures. And under Vermont law, those include mediation, where both parties jointly agree to work with a mediator to reconcile differences, and fact-finding. So mediation is not a required step, but fact-finding is. So you have to exhaust the fact-finding process in order for a board to invoke so-called finality. So a fact-finder hears from both parties on the issues in dispute and issues a written report within 30 days of being appointed. This report is advisory only and is made public within 10 days of delivery if issues remain in dispute. One thing I want to add about fact-finding here is that fact-finders tend to be very conservative, and they will look at issues in terms of comparability, established practice, and really tend to be unwilling to venture into uncharted territory. So if boards are looking for innovative contracts, they should not rely on the fact-finding process because that's just not the way it was designed to work. One other option that is available, but to my knowledge has not been used in Vermont, is to go to arbitration. This is upon mutual agreement of the parties. And basically, I think the reason a lot of people don't do it is that you've handed control over the final decision to a third party who has the power to determine all the issues in dispute. So that's what happens if you initially can't come to agreement. And then what about if after receipt of the fact-finder's report you still can't come to agreement? Then after 30 days, and you do have to wait 30 days after receipt of the report, the school board can invoke finality. You can only make final decisions or impose terms on matters that are currently in dispute. So any matter that's not in dispute cannot be unilaterally changed through imposition. Imposition may be for one school year only and cannot impose financial terms retroactively, only prospectively. The other side also has some abilities here. After 30 days, the teachers can strike. The only reason they can is if both parties have submitted to final arbitration. And in the case of a strike, a board could seek an injunction if they can demonstrate the strike poses a clear and present danger to a sound program of school education, which is in the best public interest to prevent. That's a pretty narrow set of circumstances that where a court would be willing to issue an injunction, and I'm happy to talk with folks about that at some other time if you have questions. So that's the process governing teachers. In terms of different rules for non-licensed staff under the Municipal Labor Relations Act, the scope of bargaining is different. So there it's wages, hours, and conditions of employment. The Labor Board has said that means any condition of employment directly affecting the economic circumstances, health, safety, or convenience of employees, but excluding matters of managerial prerogative. And here's some just concrete examples of what would be included in the scope of bargaining for your non-licensed staff. The dispute resolution procedures are the same, although there's no clear right to invoke finality under the Municipal Act. And the right to strike is limited and can be enjoined if there's a danger to health, safety, or welfare of the public. So those are sort of the significant differences between the Teaching Act and the Municipal Labor Relations Act. The municipal law outlines unfair labor practices, which also apply to bargaining under the Teachers Act. So the Labor Board has the power to determine whether an unfair labor practice has been or is being committed, and they will basically make an order which can be enforced through Superior Court. And the statute in Title 21 lists a number of unfair labor practices, and I have 4 here that I think are particularly pertinent to school districts. So the first is a failure to bargain in good faith. And so unfair labor practices can be committed by both employees and employers. So employers cannot interfere with, restrain, or coerce employees in the exercise of their rights. And employers cannot, and employees cannot restrain employers in the selection of their representatives at the bargaining table. Employers can't discharge or discriminate against an employee for filing an unfair labor practice or for belonging to the union. And it would be an unfair labor practice for a board to refuse to appropriate sufficient funds to implement an agreement. Those are just some examples of unfair labor practices. And again, those are argued in front of the Labor Relations Board. So I'm going to stop here and take some questions. Steve, please tell me we've gotten some questions.
We do have some questions. Can you hear me? All right, hopefully people can now hear me. We have several questions that have been raised over the last few minutes. One relates very specifically to the issues that Nicole was just reviewing, and I'm going to ask Ken if you would, Carrie, if you would unmute Ken, and Ken has a question. So Ken, why don't you ask it?
Okay. Can everybody hear me?
Yes.
A short while ago, the commissioner favored a no strike clause, and I wonder what VSBA thinks about that.
Okay, thanks, Ken. Thanks, Ken. It's a question that a number of people have asked us. The proposal that was made by the commissioner and that has been discussed off and on is some kind of binding arbitration I don't have the right term exactly for that. Binding interest arbitration, where basically at the end of the whole process that Nicole went through, there would be you would get to the final stage, and the final stage would not include a strike, and it would not include imposition. Instead, it would include each side submitting its basic last best offer. Those of you that are baseball fans are very familiar with this kind of arbitration, where both parties try to put forward proposals that are realistic enough that an arbiter would choose their side, and then the person who is hired to make the decision would choose either A or B, but would not kind of create a whole new reality. Some people say, well, why wouldn't we all love that? It would avoid strikes and so on and so forth. We have two major concerns about that. Number one, because it is not clear who the arbiter would be, you have an unaccountable person, somebody who's not elected, who's not accountable to the voters or the taxpayers or anybody else, making a decision which could radically change the landscape in terms of payments. So we've been slow to buy into that. And the other is that it guarantees incrementalism. It guarantees that the board is not going to be proposing anything very radical, and it guarantees that teachers are not going to be getting into sort of a radical change in a contract structure. It pretty much guarantees people have to start with the current process and do something very modest and incremental. And we are at a time where I think we should all be being much more creative. So we have been reluctant to buy that as the simple solution to avoid strikes. Instead, we really think that we and the teachers together should be trying to change the focus, really focusing on where we want education to go, how we're going to meet the needs of every child, how do we engage in more collaborative processes. And we do have a number of districts in the state that have tried out a variety of approaches that are quite promising. So we think that we're better off to put our time into trying to keep moving the system forward, focused on kids, rather than on getting into a sort of a quick avoidance of the problems we've had and sacrifice the most important things in the process. There were several other comments made. There was a question about collaborative bargaining resources, and unfortunately on the screen that I have, I didn't dissect the question properly. I wasn't fully understanding the question. But someone asked about collaborative bargaining, and Nicole, what specifically what is the organization that offers those collective bargaining resources? Can you?
Yeah, sure. Yeah, sure. It's the Federal Mediation and Conciliation Service, which, sorry, we're having technology issues, which will work with a bargaining team to free of charge to train them in the collaborative bargaining or interest-based bargaining process, and provide ongoing support to that team as they work out the kinks in the process. So I have, I'm not sure I have their website on the slide here, but I believe it's fmcs.gov. It's a federal program, as I said, free of charge, and I know that at least one district in Vermont has worked very successfully with them in the past year, and speaks very highly of the process.
Great, thanks, Nicole. There was a comment made on how much more complex things have become with multiple towns, and especially with the dynamics that occur when you've got different histories, different traditions, different contracts. And it's important just to acknowledge that that's part of the reality. We are in the midst of this transition from individual negotiations, individual town negotiations, to supervisory unions. And it simply says to me that we need to make sure that as supervisory unions we begin to develop a broader vision for what you want to have happen in your broader district. And it doesn't happen quickly or automatically, but we certainly would encourage people to together try to raise the discussion to a much higher level, which can help you get beyond the nuances of five different contracts. There was also, well, there were a couple of comments about how we break the incremental cycle. There were several people that have commented how it's just really hard to break out of the current cycle that we're in, where people basically put forward unrealistic demands on both sides, and you're sort of in that back and forth dynamic until eventually something gives and people settle, but it's not a creative process. And I guess our pitch to you all would be to have these discussions both within your board and with your superintendent, and to encourage your teachers to engage in child-focused conversations. We are doing our best as an organization to reach out to various people, including the NEA, to begin to have this kind of a conversation on a statewide basis. You know, that'll be a long conversation, and we don't, you know, thus far we haven't made a huge amount of progress, but we continue to raise the issues, and we're hoping to have some a number of direct conversations with the NEA, but also with legislators, the governor's office, and so on, because this needs to become a society-wide conversation. Each individual board is not going to be able to fight this fight each time you sit down to do collective bargaining. Some have, and some have successfully, but the system will not go through any kind of transformative change unless we're working on this on multiple levels. Couple of other questions that
I just would like to.
Oh, okay.
I just would like to wait, and I think that's another reason it's so important to view this in the view collective bargaining in the context of what you're trying to accomplish, both in your district but also within your supervisory union, and that you boards pay particular attention. It's important for us to have that conversation at a state level, but it's also important that the types of activities I talked about earlier tonight in terms of setting the context are so important, because boards need to feel like they have their community behind them, they have students behind them, they have teachers behind them when they're charting this new direction for their school systems.
While we're on some of these conversations, a follow-up question has been made or has been put forward. Does the Federal Mediation Service, is that the correct term?
Mediation and conciliation.
Yeah. Do they train just boards or NEA negotiators as well?
They work
with both parties to the negotiation. So whoever the teachers negotiation council is for the SU and the board negotiation council, both parties go through the same training together, and so it's both. Both parties have to be willing to participate.
Are there any other Are there any other questions that people want to put forward at this point about anything that's been discussed thus far? Or again, I'm going to ask the question, is there anybody that would like to come on the line verbally and share a particular, something that has worked well that others could benefit from? We welcome you to come on, so feel free to put up your hand and if hopefully you know what I'm talking about when I say put up your hand. There's some kind of a little icon that you can click on, and would love to hear from. Oh, there's a hand. All right. So we're going to call on Henry, and we're going to, if you can make your point reasonably quickly, and we'll go from there. So Henry, you've been unmuted, so go ahead. And actually, if you'd introduce yourself and your board, that would be good.
My name is Henry Wilmer, and I'm on the Lincoln Community School Board in Addison, Northeast.
Great.
And thank you. And for better or for worse, we think for better, we have had two teachers who attend our board meetings, and they have consequently had a much better idea of some of the issues we wrestle with, and that has seemed to be a positive.
That is excellent. We appreciate you sharing that. Certainly anything that can be done, I think actually you're going to get to that in a little bit, Nicole, but anything we can do to improve understanding, improve communication, and improve a mutual focus on the interests of students is a great thing. So thank you, Henry. Appreciate that. Anybody else want to share an idea or an experience? Okay, I think what we'll do is we'll move on to the next segment with Nicole, and you can be thinking about other things you'd like to discuss, because at the end of this session we should have 10 or 12 minutes to actually have a conversation back and forth, and we would encourage people to participate. Even though this is can be a little bit awkward, it's good for us all to get experience with the technology. So why don't you go ahead, Nicole.
Okay. So, thanks to Carrie, we now have a legible comic. Before, Carrie had to clean up some of the text here. But, I mean, basically, there are countless books and resources available to boards as you think about your basic approach to bargaining at the table. One of those resources is about to come from the VSBA. Been working on a guide to collective bargaining that will be released by the end of this, at the end of the month. And that will include a big discussion on steps that negotiators must take to prepare for actual negotiations. So I talked a lot about laying some groundwork for successful bargaining earlier tonight, and then an overview of the law, but a significant amount of work also needs to be done with regards to things like analyzing your contract, reviewing comparables, preparing communications plans. There's a lot of work that has to be done up until the point you actually sit at the table. So I hope you'll keep an eye out for that guide, and just be aware that there's a whole other area of content that you should be aware of, particularly those folks who are going to be on the negotiations council. Really need to be paying attention to all the different elements that you need to prepare in advance of actually starting negotiations. But what I'm going to just finish up tonight is a brief discussion about some basic bargaining tips for folks coming at the table. And the comic's funny because it, talks about the important thing is maintaining eye contact while reinforcing an image of strength and warmth, and that's what you need to do in order to be a successful negotiator. And I think there are a lot of images that people have out there about what makes for a successful negotiator. The tough talking, table pounding, this is my final offer image, I think, is one that's common in our understanding of what a successful, tough negotiator looks like. But we've identified some elements through research that will help your team be as successful as possible at the bargaining table. And the first is for your party to be honest and demonstrate integrity. So that means not being afraid to say, I don't know, or I'm going to go find out. It enhances credibility, it enhances respect. So don't be afraid to be honest. Probably the most important thing for your bargaining team to remember is you're there to listen carefully. If negotiators at the other side can't explain their proposals or the reasons for them, it's likely that those proposals are not essential. Listening is the most effective strategy, rather than the image of the table pounder I alluded to before, which has a place perhaps. But listening can be an incredibly effective way to understand what the interests of the other party are and what's important versus what they might be willing to give up. One thing that's hard for some boards, particularly for folks who have relationships with the teachers, perhaps your child is in the school and you're negotiating with someone who you've developed a relationship with via your own child, that it's really important not to take the bargaining process personally, that this is an open and candid discussion of proposals, and that it's natural for discussions to get unpleasant. They really shouldn't ever get personal, but they might get unpleasant, and board members just need to understand that that's just sort of the nature of the task that you're getting involved in, and that sort of what happens at the table should stay at the table. Be clear and consistent. So if a proposal is unacceptable, say no once and move on. If you say final offer more than once, it's not an effective strategy. And be realistic. So I've heard recently, tales of either party coming into the process with proposals that are wildly, unrealistic and seem designed to sort of get people sort of dug into their positions. So any initial proposal should not be so far out as to insult the association and polarize negotiations from the outset. There's really nothing productive that can be gained by floating realistic proposals that everybody knows are unrealistic. It will harm credibility, which is also, as we've talked about, an important point. Another tip is to know your association. So here's a little graphic I like. It's the old positions versus interests dynamic. It's really important for your team to determine as early as possible the association's priorities and interests. Also be aware that the association's priorities may be different from those of its members. And understanding the reasons for those differences or the politics behind a particular proposal will help you be able to understand really what you're dealing with in terms of positions versus interests. Timing is important. The team's judgment as to when a proposal should be dropped or an offer should be improved or a position sort of reaffirmed is critical. Bargaining is all about compromise. So any agreement that promotes trust and creates a mutually beneficial long-term relationship is going to require compromise on both sides. And you should be prepared to know what you're willing to compromise on and what you're not willing to compromise on. And I think always checking things back to your vision and what you're trying to accomplish for students can help you make that analysis. Now, as things are drawing to a conclusion, you want to make sure you're avoiding imprecise language. It might seem an appealing vehicle to achieve compromise or consensus, but imprecise language often works to the employer's detriment. So be as precise as possible while still obtaining agreement if that's where you're hoping to go. And finally, don't finalize complex language in a hurry. So for those of you working with an attorney, take the time to agree in principle, but then draft the language, review it, and then finally jointly finalize, so that you're not caught a year from now looking at language that really doesn't work for the for your administration without knowing it. And I think the most important thing for boards is if you've done the vision work ahead of time, as we're recommending you do, that when you're at the table you keep that picture, that vision in your mind, and you use it to guide and ground your proposals and to justify your reactions to proposals. That vision should help you, you know, refrain from shying away from difficult positions, and give you sort of the foundation to stand up for them, and be able to explain them clearly to the other party. And it will also help you develop clear and consistent communications to keep everybody apprised of the process, and keep reminding people what you're trying to achieve. Steve. That's Steve. So the last piece I want to talk about before we get into a more free-flowing discussion, and this relates to the suggestion that was brought up earlier about teachers coming to board members, that it's just as it's important for the board to lay a lot of groundwork in terms of engaging the community, developing a vision for what you want to achieve at the bargaining table. It's equally important that once that process concludes, you don't walk away and say, great, work done, see you in 3 years or 2 years. It's important that the board remain engaged. So immediate step is that after the contract's ratified, board members thoroughly review and explain all contract provisions with administrators and the community. So you ask the community for permission to chart a new direction for your school. It's really important that you go back and tell them what you were able to accomplish. And then this is specifically related to the other point raised by Henry, I believe. Think about designing a structured process for the board to stay engaged. This looks differently in different places. Sometimes these structures are called labor management teams, where representatives from the board and the Teachers Association meet on an ongoing basis to discuss things that come up related to the contract, issues sort of more generally, and they are a nice way to build relationships and solve problems when they come up, rather than waiting for negotiations to resume to start to address some issues. Another, I mean, I think it's all semantics really, is advisory council. So you could establish a board and teacher, parent, student council to talk about ways to move your system forward in ways that meet the needs of students, that sort of keep track of any labor management issues that come up during a year and seek to address issues in real time rather than at the bargaining table. And then the final piece here is for the board to seek timely and accurate information from the administration related to progress towards the board's vision, and that's not solely related to issues related to labor management, but just generally, you know, this is the direction we said we wanted to go. How are you going to know if you're getting there? If you fought hard for a particular element of flexibility in your contract because it was suggested that that would lead to more opportunities for students, well then you better want to see what those opportunities for students are, because not only is that going to give you, you know, important information regarding how well your system's functioning, but it's important information for the community to have about the progress that you're making generally and what sorts of new directions you might want to push for in the coming negotiation cycle. So that's the end of the content piece from my end. I would really love to hear from folks in the next 10 minutes or so. We're going to save